This is People of the State of Michigan versus Antonio Urban, docket number 20-274FH. And this is the time set for I believe, a final pretrial, and then also the people's motion to exclude evidence under MRE 609. And Ms. Allen is here for the people, Mr. Berry for the defendant, who is also present via Polycom from MDOC. Ms. Allen, you want to take your motion?
I'm sorry,
Yes, Your Honor. Thank you.
Wait. What?
There's people in the background.
Oh, okay. I'm going to mute Mr. Urban's end, and because there's people in the background interfering with our ability to make a record. I'll unmute you if there comes a time when you need to say something, Mr. Urban. Okay, start over, please. I'm sorry.
Thank you, Your Honor. The people filed a motion to exclude evidence under MRE 609. We received the response from the defendant, and he agrees inadmissible under 609. However, he would like the court to admit this evidence under MRE 608B. So if I may, I'd like to respond to his response regarding that.
Okay, I didn't get his response, but go ahead.
Okay. Well, Your Honor, he argues that under MRE 608B, he should be allowed to admit this evidence because subsection B says specific instances of conduct of a witness for the purpose of attacking or supporting the witness's credibility other than conviction of a crime as provided in Rule 609 may not be proved by extrinsic evidence, but in the discretion of the court, if probative of truthfulness or untruthfulness may be inquired into on cross-examination of the witness regarding if it's concerning the witness's character for truthfulness or untruthfulness. So in his response, he said, although these convictions would not be admissible under 609, he could inquire of them on cross-examination under MRE 608B. However, Your Honor, I would ask the court to deny that request. First, I don't think that these convictions that we have here or acts underlying the convictions are probative of truthfulness or untruthfulness. What we have is a witness who had suffered from a drug addiction years ago, worked to get sober, and we have two older convictions, which are more than 10 years old, and a 2017 misdemeanor case, which was retail fraud. And all of these would have been excluded under MRE 609. And the theft in and of itself is not an act of untruthfulness. It's an act of theft. These are different. It doesn't require a person to speak, to lie, to falsely accuse. And it's our position they would still be inadmissible under MRE 608B. And secondly, they would be inadmissible because they're still subject to an MRE 403 analysis, which, as this court knows, although relevant, evidence can be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, misleading the jury, or by considerations of undue delay, waste of time, needless presentation of cumulative evidence. And the convictions we have here, like I said, are retail fraud from 1996, prescription fraud from 2008, and a retail fraud from 2017. Probative value here is substantially outweighed by the danger of unfair prejudice or confusion of the issues. And are guided by, I think this court should be guided by 609 when we look at whether or not this evidence, because 609 addresses how prejudicial these convictions would be if presented to the jury. And in subsection C of 609, they put a firm 10-year time limit on these prior convictions, which makes sense because of the age. I would say that they're presumed prejudicial because of that. I'd ask the court to apply that same, after anything older than 10 years is not only unfair prejudice, but it's not relevant. The victim here was a victim of a home invasion and armed robbery, and a prior act underlying a conviction from over 10 years ago or a misdemeanor conviction are not even relevant. I also think, I'm not sure how counsel could even ask about these acts without violating MRE 609. If he asks, did you steal from a store in 1996? He's asking information of that witness. If she answers yes, she's admitting to a crime, which would be barred under 609. So I don't think that we can segue this into a 608B for specific instances of conduct when 609 specifically excludes these convictions. So, Your Honor, I know you're just catching up here a little bit because you didn't have the defendant's answer, but we'd ask the court to exclude it under 609 and under 608B, even as the defendant has proposed it. Thank you.
Okay. I now have the defendant's answer in front of me, but go ahead, Mr. Berry.
Thank you, Your Honor. I'm sorry for some reason the court didn't get that. Just for the record, I served that on October 12th. Miss
Yeah,
Allen,
wait a minute. You have to send a judge's copy or I don't get it.
that must have been what happened. I apologize.
Yeah.
So Miss Allen partially indicates the defense position correctly, but I think it's somewhat misguiding because it would not be to introduce evidence of the conviction itself or to ask about the conviction itself. The proposal to admit the questioning under cross-examination under 608, as indicated, I think what I believe to be correctly under paragraph 6 of the response, is that I may be allowed to inquire as to specific incidents of conduct that, and though that conduct may have included that her commission of a criminal offense that ultimately resulted in a criminal conviction, 608 does not say whether or not someone can inquire into such conduct if it resulted in a conviction. Let's say I have evidence that she did such acts and she was never ultimately convicted. I would think, I don't know Ms. Allen's position, but I would think at that point she would concede that I would be allowed to inquire as to those acts. To somehow now say that I can't inquire of them simply because she was convicted, I think is not in the correct application of 608. 609 says that I can't admit the evidence, the extrinsic evidence of the conviction. I concede that. I will not be able to present the extrinsic evidence to say, no, you were actually convicted of it. What I can do is ask her about her involvement in that underlying conduct and just take her answer. I would not be allowed to introduce the extrinsic evidence of the ultimate conviction. Now, if she wants to perjure herself and deny whether she actually did it, that's on her. But she certainly wouldn't necessarily have that she was convicted, and I certainly wouldn't be allowed to ask whether she was convicted. But I would be allowed to ask to inquire as to that conduct. And I think it's somewhat disingenuous to take the position that these don't involve crimes of dishonesty when that was the whole point of the 609, motion itself, is they do, but they've gone beyond the scope of the time frame of the incident itself. And so I didn't even expect to really get into it, just relying upon the briefs, but I apologize. The court didn't have an opportunity to do that before, but that's my position. I can inquire into it. She can respond and then move on.
Okay, thank you. Well, these clearly, the original motion was to keep them out under 609, and I think the defense agrees with that. I just want to say the reason the defense probably agrees is that 2 of them are more than 10 years old, so they could not come in under the bright line rule of 609. And the third one is not punishable by can't remember if it's a year or more than a year, but in any event, in excess of 1 year. So that the third one is within 10 years. It's more recent, but it's a 93-day misdemeanor. So under the bright line rules of 609, none of these come in. So the defense proposal is that they come in anyway under 608B. But 608B specifically excludes convictions of a crime as provided in Rule 609. I do think there is some appeal to the prosecutor's argument that how else would you bring these things in? You can't really talk about the underlying conduct without actually describing the criminal offense. Did you steal from a store? Did you possess a forged prescription? Did you obtain controlled substance through fraud? I mean, that's basically what the inquiry would be. But let's give the defendant the benefit of the doubt and say, no, you could describe the underlying conduct without mentioning the actual crime itself. The 608B says that specific instances of conduct of a witness for the purpose of attacking or supporting the witness's credibility other than conviction of a crime as provided in Rule 609 may not be proved by extrinsic evidence. They may, however, in the discretion of the court, if probative of truthfulness or untruthfulness be inquired into on cross-examination of the witness concerning the witness's character for truthfulness or untruthfulness. So first of all, I would say and point out, this is not an absolute rule. It's in the discretion of the court. And we have to apply Rule 403 to it as well. So first of all, 1998 retail fraud in the first degree and 2020 retail fraud in the third degree are not crimes or actions that demonstrate the witness's character for truthfulness or untruthfulness. They are theft offenses. The 609 distinguishes crimes involving an element of dishonesty or false statement from theft offenses. And I think we can make the same distinction under Rule 608, and these are theft offenses. So I do strongly disagree with any suggestion that these are offenses that go to truthfulness or untruthfulness. The only one that could be said of is the obtaining a controlled substance through fraud, which if it were not, if it were within the 10-year period, could conceivably qualify under 609. But that offense, even if it came in under 608B, is not admissible in the opinion of this court when you apply MRE 403. This is from 2008, and I think that it is a very limited probative value for something that happened so long ago. It would tend to mislead or confuse the jury. It would divert them from deciding what they need to decide. We would get into perhaps a mini trial on why and how she engaged in this activity and what she was experiencing at the time and what the circumstances were at the time. So evidence, even if it's relevant, can be excluded by the court under MRE 403. And I find that the two retail fraud, I won't call them convictions, actions, if you will, are not probative of truthfulness or untruthfulness. And the 2008 obtaining controlled substance through fraud is excludable under MRE 403. So I don't think that even if we talk about just the underlying actions, that any of these three should come into the trial, and therefore the prosecutor's motion to exclude this evidence under MRE 609 and even under MRE 608 is granted. And is there anything we need to place on the record for our final pretrial?
Yes, Your Honor. I've been emailing with Mr. Berry because we've been discussing plea options, and I just want to place that on the record. It sounds like the defendant this time is not willing or to accept that, but I want to make it a part of the record, if I may.
Sure, go ahead.
So currently this defendant is charged with, in addition to other charges, the armed robbery and the home invasion first. Because he was on parole, he is not receiving any credit, so he has 0 days credit. And at trial, we have run his guidelines to be 171 to 356 months, which is 14 to 29 years just on the armed robbery, which would be discretionary, if convicted at trial, discretionary consecutive to home invasion first degree, which I have as his guidelines 7 to 15. And then those would be consecutive to felony firearm second, which is a mandatory 5 years. So just to place on the record, if defendant, as we have him scored, was convicted of just armed robbery and felony firearm second, he's looking at possibly 30 years plus an additional 5. At this point, and if he's convicted of home invasion first and ordered to be consecutive to the armed robbery, he's looking at potentially 30 years plus 15 plus 5. I just want to place that as part of the record. At this time, we have offered him at this point to plead guilty to home invasion first, plus a felony firearm first, where we would give him a cap at 96 months on the home invasion first, which would be 8 years plus the 2 years on the felony firearm. So our offer, if he pled guilty, would be that he would be getting a 10-year sentence to be served consecutive to his parole sentence. That would be when his minimum, he'd be eligible for parole on the offer we have made. So I just want to place that all on there, what he's potentially facing and what we have offered him at this time. I believe Mr. Berry's explained all of that to him, but I'd like him to hear it and reject it on the record.
Okay, and I'm unmuting your client, but Mr. Berry, did you have anything to add to that?
Well, I would just inquire, Ms. Allen, I had, from our exchanges and emails, the last offer was home invasion first, that 8 year, and not to score the firearm, no other charges. Is that no longer the offer?
Right, okay, that was the last one that we made then, home invasion first with an agreement of 8 years. Sure.
Okay.
Yep.
And Mr. Irvin, understanding the potential consequences, do you understand, were you able to hear Ms. Allen?
Yes.
Were you able to understand the potential consequences and how many years you'd be facing if you were convicted at trial of all the charges?
Yes.
You understand you have an offer before you today that if you would like, you could accept an offer to plead to a home invasion first offense, dismiss everything else, not score the possession of a firearm, the sentencing guidelines, and a set minimum sentence of 8 years.
Yes.
Do you choose to accept or reject that offer?
I'm rejecting it.
And do you understand that there's no guarantee that you will be provided any other offers going forward and that this matter will be scheduled to proceed to trial, currently scheduled for April 5th?
Yes.
Okay, thank you, Your Honor.
All right, thank you. Then if there's nothing else for the record, that will conclude our hearing.
Thank you.
Thank you, Judge. I'll submit an order on the on our motion. Thank you.
And
Okay,
Ms. Allen,
Mr. Urban,
I just want to say, Ms. Allen, you could just do that by stipulation. We don't need to do a 7-day.
okay, Mr. Urban, you're all set. You can tell them they're at the prison that you're all set.
All right.